Thanks, Acting President. I rise to speak on the Mental Health and Wellbeing Bill 2022. It is a bill that has been born out of the Royal Commission into mental health and acquits the government of its commitment to introduce the bill before the election on the recommended timeline of the Royal Commission. Whilst it is slightly flawed in some areas, in the opinion of our party, we still will be supporting this bill. There are many things to be optimistic about with the passage of this bill, including a more therapeutic approach to mental health issues and significantly more investment in the sector. It was an ambitious task to have this bill consulted on and drafted in the short time frame as stipulated by the Royal Commission. There are feelings out in the healthcare community that the government are pushing this bill through now because they're sticking to the somewhat arbitrary timelines provided by the Royal Commission, but they are doing it at the expense of getting the bill perfectly right. I appreciate the desire to pass these reforms and start implementing their contents, but the reality is that this bill does not actually come into effect until September next year, so there would have been some time to fix up some of these issues. Regardless, it brings me to the first issue with the bill, which is around consultation or the lack thereof. This bill has had 2 years of consultation before it was introduced, but there is a difference between receiving feedback and actually putting that feedback into the bill. The government have had to deal with competing interests, naturally, between the healthcare sector and the lived experience advocates and carers. This is unenviable, but it is clearly still flawed, and the review in 5 years should not be pointed to as the time to fix current issues. One stakeholder told us they had 1 weekend to look over a section of the draft bill before feedback was expected to be provided before the bill was introduced. This meant that non-lawyers had a weekend to look over 500 pages of legal jargon. I hope that in the future there is a political will to fix the bill that will inevitably need to change. In relation to the bill's move to the health-led response, as a police officer, I've had frequent duty of transporting and sitting with mental health patients, or as a force would be familiar with as sections 351s. This refers to part of the current act that allows apprehension of mentally ill member of the community. The new health-led response will change the way that mental health episodes are responded to. Police will still have a role in the system, as they always will, in my opinion, as long as there are drugs and alcohol in the community. But this role will be complemented by others, such as paramedics, psychiatrists, PSOs, and future prescribed persons. This has not resulted in a rejoice from police officers saying one less job to do, but police do recognise that they are often not the best people to deal with mental health patients. Many patients have had negative interactions with the force. Many police members, whilst they are trained, do not have the level of training required for some patients where they perhaps pose no physical danger to others and can be treated or transported without apprehension. Further, they're not equipped with the knowledge of the sector and the broad available help. Our job has been to try to de-escalate, apprehend where needed, and to transport to hospital. From there, it is up to the hospital to deal with the patient. Frequently, I've been held up for over 6 hours waiting for an admission at a hospital with a patient as a police officer. In real terms, that's 6 hours that a divisional van is off the road. Almost a whole shift consumed in guarding a mental health patient and not being able to provide the community with any law and order response. A recipe for disaster. It needs to change sooner rather than later. There are 1,000,001 questions about how this bill will play out in practice. Who will be the first port of call to respond to these incidents once 000 is called? The yes to call taker likely won't know how serious the situation is. How do we know if the person has been affected by drugs or alcohol and could therefore be unpredictable? Who does the risk assessment on the patient? Who transports them? What restraints are able to be used and what threshold? Who takes on the indemnity of such potentially volatile situations? Are psychiatrists and nurses and others without weapons such as OC sprays, etc., happy and willing to take on this role? Are we likely to lose healthcare staff, of which we're already struggling to keep, by keeping them the first port of call for mental health patients? This shows that there are unknowns that we believe should have been figured out before this bill passes. There are questions that need to be answered, and I hope the Minister representing the Minister for Mental Health will be forthcoming and answer those questions in committee. One of the more contentious parts of the bill is the rhetoric around restrictive interventions. And this includes the restraint, both physically and chemically, and the use of seclusion. I have to say that the voice from the healthcare sector has been united behind closed doors. While some of the public statements might be a bit more relaxed, they were collectively unsatisfied with the wording of elimination of seclusion and restraint and how it has been translated into the bill. They also reject claims by the bill that such practices serve no therapeutic benefits. What are the potential outcomes of these laws? Healthcare workers losing morale, walking off jobs potentially and refusing to deliver care? Unlikely. Mass resignations and or increased healthcare worker injuries or deaths for those that run the gauntlet of providing care for what's under proposed. For instance, the AMA says, and I quote, "Eliminating these practices entirely will inevitably result in mental health services being unable to meet the health needs of a small but significant proportion of seriously mentally unwell consumers." Unquote. And further, I quote, "In legislating on the reduction of restrictive practices, the support to mental health services and workforce needs to be considered and provided for." Unquote. This hasn't happened. The AMA called for the bill to be considered by a Legislative Council committee for further review and consultation. The National Association of Practising Psychiatrists were also very unsatisfied with this part of the bill. Despite these bodies trying extremely hard to work with the government to make a few tweaks in respect to the above, the government has not introduced these as House amendments. Specifically, the sections of the bill that they believe should have been reformed include the fact that the Health Secretary and Chief Officer for Mental Health and Wellbeing are being tasked in the bill to set targets to reduce and ultimately eliminate the use of restricted interventions in mental health and wellbeing services, as set out in sections 254 and 261. And section 81, which states that, and I quote, "The use of restrictive interventions on a person offers no inherent benefit to the person." Unquote. I would completely disagree on the latter as well. If a person is restrained to stop them from committing suicide, then I think that it is a benefit. If a person is chemically restrained to prevent them from harming other patients or staff, that is absolutely a benefit. If a patient is secluded to calm down after a period of psychosis to prevent harm to themselves or others, once again, another benefit. These restrictive interventions, whilst they should not be used as a first response, should not be condemned as having no therapeutic benefit. By preventing violence and harm and thereby preventing a criminal justice response, we're adding a huge benefit to the care of that patient. Put simply, it is the view of most healthcare bodies that Darren Hedges Justice Party has spoken to that some new sections of references to restrictive interventions need to be reconsidered. That brings you to my next point, that such practices will be considered by an independent panel from October. But the recommendations of the panel won't be handed down until after the new laws are fully functional. This panel was created by the former minister, and there was a lot of issues that hadn't been resolved from the Royal Commission and that weren't going to be finished in time for the bill. The minister said in his second reading speech, and I quote, "One thing we heard very strongly was a need to delve deeply into the laws around compulsory treatment and restrictive interventions. Key stakeholders called for more time to work through these complex issues, outside the tight timeframes for the introduction of this bill. For this reason, we announced in December that an independent review panel will be established to examine best practice in modernising these laws for a future amending bill." Unquote. This means restrictive interventions will be considered by the panel, right? Well, I can't tell you for sure because the terms of reference for the panel come out in October, after this bill is passed. Ridiculous, given that the panel was established last December. And shouldn't the terms of reference have been established some time ago? Perhaps a question that could be asked in committee. The government says that while the intention to conduct the review was announced in December 2021, the panel was only appointed recently, but they were announced in June and it's now August. Either things are moving slowly or there is something strategic perhaps about the timing of the releasing of the terms of reference. The people in charge of creating the terms of reference include 3 former patients, 2 carers, 1 peer experience worker, which is likely another former patient. The AMA says there was likely inherent selection bias in the application and selection process for this committee, as those who have strong opinions on compulsory treatment would have applied. They say this does not represent a true cross-section of professionals involved in treating psychiatric illnesses treated under the Mental Health Act. The AMA has made sensible recommendations about increasing the diversity of the panel, including representation from the emergency physicians and nurses who have no voice in the committee. And I would say to the government, you should absolutely consider this. On the issue of the definition of paramedic, my colleague Ms Maxwell will likely ask some questions in committee about the implications for qualified paramedics who do not work for Ambulance Victoria. This bill limits their scope of practice despite them being qualified. Whilst we understand there is future scope to include such community paramedics, we think this should be done expeditiously. Not only because they are qualified, but in many circumstances, they are more qualified than other healthcare professionals who will be required to attend acute mental health incidents. Further, the workforce will require a boost with numbers already dwindling. Lastly, my colleague Ms Maxwell raised the issue of forensic care and a startling statistic that People with serious mental illnesses are 3 times more likely to engage in offending and 4 times more likely to commit violent offences compared to other Victorians. We hold concerns over day release policies of places such as Thomas Embling Hospital, and would make the point that victims and their families should always be consulted and informed about such decisions where they may be effective. I'd like to thank some of the key stakeholders whom we consulted on this bill, including HACSU, the Royal Australasian College of Psychiatrists, VADA, the National Association of Practising Psychiatrists, Police Association and the Australian Medical Association's Victoria Division. We also spoke to individuals in the healthcare sector who spoke in their personal capacity, some with over 40 years' experience. I'd like to thank all those who bravely contributed to the Royal Commission, including those who have lived experience and those who care for others with mental health conditions. You never know when you will be affected by mental health, either through our own experiences or someone we love. So this bill and the focus in Victoria is very much welcomed, and I commend this bill to the House.